a rollover crash, a DUI arrest, and yes, another Tiger Woods mugshot. But here's the question, can they convict this on a 000 breathalyzer reading? Court is in session. We start with the facts. This happened around 2 p.m. near Tiger Woods' Jupiter Island, Florida home. Police say he was driving fast on a 2-lane road, tried to pass a truck, clipped a trailer, lost control, and rolled the SUV onto its side. He got out, no major injuries, but when officers arrived, they said he showed signs of impairment, drowsiness, slow behavior, and possible drug or medication influence. So they gave him a breath test. 000. No alcohol. Then they asked for a urine test. Tiger refused. He was arrested for DUI, and here's the key. Police never got a warrant for blood. So, as a sheriff now admits, they may never know what, if anything, was actually in his system. That is the case. Crash, observation, refusal. That's it. Let's examine the prosecution's case. The prosecution does not need alcohol. They only need to prove impairment. And they'll say this case is stronger than people think, because this is not, oh, he just looked tired. This is speeding, contact with another vehicle, a rollover crash, officer observations, and refusal to test. And refusal matter, because their argument is simple. He knew what was in his system. They may also try to point to his history. Tiger had a prior DUI-related arrest in 2017. That ended in a reckless driving plea after prescription drugs were involved. So the prosecution media framing is, this is not random. This is a familiar pattern, but the defense must be aggressive. The defense has one word: proof. Start with the breath test. 000. So this is not alcohol. This means the state is really saying something else was in his system. And the defense answer is, then show it. Because right now there is no blood test, no urine result, no confirmed toxicology, no science tying any substance to impairment. And that matters because after a rollover crash, a sober person can also look slow, dazed, confused, exhausted. So what officers saw may have been intoxication, or it may have been a man who just rolled over his SUV. And there's a refusal. Yes, that refusal hurts, but after a prior DUI case, it is also possible Tiger learned one lesson. Do not help the state build a case. Before I rule, let's examine the charge. 3 questions decide this case. Number 1, if police really believe drugs were involved, why didn't they prove it? No warrant, no blood, no chemistry. That is the whole. Number 2, what exactly does impairment mean? Not vague words. What exactly did he do that could not also be explained by the crash itself? Because after a rollover, a sober person can look terrible. Number 3, what does refusal really prove? Suspicion, yes, but proof? No, because refusal can raise questions. It does not answer them. Now, my ruling. Yes, this case is dangerous for Tiger. The optics are bad. We have the crash, the speed, the refusal, the prior history. That is enough to make most people say, here we go again, get a driver. Come on, he was impaired, with a wink. And maybe he was, but maybe is not enough to convict. So based on what is public right now, I would not convict. Not because he looks innocent. He doesn't, but because in a DUI case built entirely on invisible impairment. The state had one job, and only one job: prove what was there. If they didn't think they could convince a judge who knows the law that probable cause existed for blood or a urine warrant, then from my view, they sure can't convince a jury beyond a reasonable doubt without it. Case closed. This is Crimes Digest, where we cross-examine the crime. If you want more cases tested like this, subscribe, and I'll see you in the next episode.